Thomas. He doesn't need any introduction because he is so popular among all the HR professionals in this part of the country. But still, if there are some new faces, I will just give a brief introduction also. It's always a pleasure and fortune to have associate with Mr. Benny B. Thomas because, even in my personal capacity, whenever I associated with him, whatever we have discussed and entrusted to him, the success rate was 100%. So that's a simple secret. If you want to be successful, associate with the successful people. So he belongs to that category and success is guaranteed. Advocate Benny B. Thomas, he has got 34 years of experience and he has been handling labor laws and labor-related matters for more than 3 decades in the High Court of Kerala and tribunals. And he's one of the most sought-after labor law advocates in the country. He is the founder and managing partner of Thomas & Thomas Associates, a premier law firm. I remember even when Mr. Ratan Tata came to Munnar, he was there with him and Mr. Tata was saying, this was almost 15 years back. We've got a very, very young advocate for the Tata Group company. So that's a compliment. So we are very fortunate to have Advocate Benny B. Thomas with us. On behalf of everyone present physically here as well as on the online media, let me extend a hearty welcome to Advocate Benny B. Thomas. Along with that, I take this opportunity to welcome each and everyone. People have joined from different parts of Kerala, even outside Kerala. So let me welcome all of you to this very interesting Bonus Act latest amendment session. And as I mentioned earlier, the session will be followed by a brief Q&A also. Thank you very much for your patient listening. Thank you. Now I invite Advocate Benny B. Thomas to take on with the session.
Good evening, everyone. So NIPM contacted me on Saturday and wanted me to deliver a lecture on the latest judgments on Payment of Bonus Act. And the time given is 6:30 to 7:30 p.m. So I don't know how many participants are there because definitely a wrong time after the working hours, going home and then again participating in a session normally is not very, nobody will be very keen. So I don't know the timing of NIPM. Johnson says they normally do it between 6:30 p.m. and 7:30 p.m. So that way, if you look at it, fine. I appreciate your patience and I appreciate your regard to the NIPM. So now the main reason for this session, according to NIPM, is the judgment delivered by the division bench of 2 high courts, and following that, the judgment delivered by the Kerala High Court. Okay, so now in 2016, January, the Government of India came up with an amendment to the Payment of Bonus Act, and that is called Payment of Bonus Amendment Act 2015. Though it is in the year 2015, it came into effect on 1st day of April, 1st day of January 2016. And unfortunately, the act, they brought into effect from 1st day of April 2014. So when they came up with the amendment in 2016, it was actually the accounting year 2015-16. But the amendment was brought in with effect from April 2014. That means 1 year prior to the accounting year. So it is previous year also was considered by the legislature, and the amendment was made with retrospective effect. This question was challenged by several establishments by filing writ petitions before various high courts, and the main question was whether an amendment could be brought in with retrospective effect. Normally, as you know, Payment of Gratuity Act, even the PF Act, ESI Act, every statute the amendments come. So it is Payment of Gratuity Act. You know that it is raised from it is a 1 lakh to 2.5, then to 3.5, then to 10 lakhs, then to 20 lakhs. So all these amendments came, and even EPF also, it is over a period of time, 5,000 to 6,500, 6,500 to 15,000. So there is no statute. In fact, no amendment was brought in when the finance is involved, when the monetary liability comes. Normal course, no amendment is made. Generally, no amendment is made with retrospective effect. Because so that the several establishments challenged it, and the main contention was the bonus was paid and the accounts were closed for the financial year 2014-15. And that was on 31st March 2015, this was closed. So then January 2016, during the accounting year 2015-16, suddenly when the legislature came up with this amendment, it was not practical for any establishment to reopen the entire accounts which otherwise was audited and closed. And the bonus also was paid, so that allocable surplus, there can be some difference. So considering all this, several establishments challenged it. And the Kerala High Court, all High Courts, Karnataka, Tamil Nadu, Andhra, then all Rajasthan, Bihar, Orissa, all High Courts, the writ petitions were filed by several establishments. And all High Courts, including Kerala High Court, passed interim order stating that this retrospective effect brought in by the legislature, that is not prima facie not legally correct, and hence the courts passed interim order staying the operation of the amended provisions with retrospective effect. Then again, there was a challenge with regard to the quantification or computation of bonus, because the amendment also says it is 3,500 was the salary for the purpose of computation of bonus prior to the amendment, and that was raised to rupees 7,000 or the minimum wages for the scheduled employment. This actually makes, create a huge difference in the bonus paid in two establishments, to which one is covered under Minimum Wages Act, the other is not covered under Minimum Wages Act. So that actually is a challenge, because nobody can never, because in the history, the Payment of Bonus Act, if you look at it, nowhere at any point of time, nowhere it is stated that bonus is payable on minimum wages. Bonus, of course, throughout there was a ceiling. It is 2,500, then raised to 3,500. So before that it was 1,000. So it is 3,500 to 7,000 fine. But then, or minimum wages, whichever is higher. So that actually was a challenge again to the establishments governed by the provisions of the Minimum Wages Act. So that again, so this was especially, for example, a hospital having around 500 employees, and the minimum wages notified is roughly around the latest minimum wages. Of course, that is set aside by the High Court last year, and the fresh notification of our revised minimum wages, the discussions are going on at the IRC, and then of course a settlement has to be arrived at, and the notification, or the government on its own has issued the notification. So definitely the minimum wages for the employees in the hospital will be around 25,000 or more than that. But even with amendment in 2018, it was more than 20,000. So if you look at the minimum wages applicable to hospitals, the bonus payable for the purpose of computation of bonus, the wages is to be considered, minimum wages if considered, it will be around 20,000. If it is more than 21,000, fine, you are safe. But if it is 20,000, then of course the liability is huge. And where the minimum wages, an industry which is not notified by them, where the minimum wage is not notified, the computation will be on rupees 7,000. So look at the difference. suppose an establishment which is not governed by the Minimum Wages Act, and where they have around 1,000 employees or 500 employees. So their bonus is calculated on 7,000. And near to that, suppose there is a hospital which is where the number of employees is only 50. And their bonus calculation will be on 20,000. So that way, if you look at it, there is a clear discrimination among the industries, and the legislature, in fact, made a vast difference in payment of or the amount of bonus payable in an industry which is governed by the Minimum Wages Act and not governed by the Minimum Wages Act. So it is a rough calculation if you look at it. 7,000, you know that it is 20%, it comes to 16,800. So when the minimum wages in the hospital, suppose it is 20,000, or rather the minimum wages notified is 2018 amendment, it was 22,000, 23,000, but since it was stayed by the High Court, most of the hospitals were paying maybe 20,000, 19,000, 20,000, that rate. So that 20,000, if you consider for the purpose of computation of bonus, so it will be around 50,000 or less than 50,000. So it is 16,800 and 50,000 per head towards bonus. So this actually the difference under the Payment of Bonus Act, whether it is legally correct or not. That was the second question challenged before the various high courts. So these two questions, according to me, nobody challenged the ceiling raised from 3,500 to 7,000. Nobody challenged it. That was accepted by all, because periodically they come with the legislature come up with amendment, and these amendments normally they raise the ceiling. So it is, as I said, the 2,500 to 3,500, fine, or even 3,500 to 7,000, fine. That also was accepted by all the establishments. But the second leg, or rather the rider to that, over minimum wages, whichever is higher, that of course was really unreasonable. And that is why that portion of the amendment also was challenged by several establishments. So the two questions, one, the amendment with retrospective effect from 2014. So it is the amendment came in 2016. So with retrospective effect from April 2014 means one more accounting year, which is all otherwise all payments were made, closed, accounts are closed, audit is over. Then suddenly the amendment is brought in. So that justifiability of that amendment with retrospective effect. One question. Second, again, payment of bonus on 7,000, fine. But or minimum wages, whichever is higher, that portion in the amendment. So these were challenged by several establishments in the year 2016 itself. Immediately after the amendment came, it was challenged before the, and it came up before Kerala High Court, of course, immediately stayed the operation of retrospectivity first, and subsequently the portion or minimum wages, whichever is higher, that was also stayed by the Kerala High Court. And similarly, Madras High Court, Karnataka High Court, Andhra High Court, several high courts all stayed. Some high courts stayed only the retrospectivity. Some high courts stayed both, including Kerala High Court stayed both. So these several orders were passed by various high courts on this issue. Of course, there was some variation in the orders. As I said, some high courts said only retrospective effect, that need only be stayed. But other high courts said no, this minimum wages, that also is to be stayed. So when since this is a nationwide issue and it's a central statute, and the legislature came up with this amendment and with retrospective effect, when you challenge the validity of an amendment brought in by the legislature, generally the courts don't entertain these kind of writ petitions, because this was the legislature to decide what amendment is to be brought in, and it is to be made effective since when. These are all, normally it is not the duty of the judiciary to look into it. It's exclusively within the control of the legislature. So that is the view of the high courts and the Supreme Court. And hence, normally the high courts don't entertain these kind of writ petitions challenging the amendments brought in by the legislature. So in this case, the high courts passed interim order because they felt that there is some injustice or some unreasonableness in the amendment. For one reason, it's made with retrospective effect. Second, the 7,000 for one group of employers and the minimum wages for another group of employees. So irrespective of the minimum 20 or 10, whatever it is, I understand. But suppose an establishment having 50, and unfortunately that is covered under Minimum Wages Act. Another establishment having 1,000 employees, not governed by the Minimum Wages Act. So it is actually the turnover difference is huge, and employees, 1,000 employees, the turnover will be huge, and the profit also will be huge. But their bonus is limited to 16,500 because they are not governed under the provisions of the Minimum Wages Act. Those days, there was hardly 50 establishments or industries were covered under Minimum Wages Act. So rest of the industries were not covered under the Minimum Wages Act. So this actually, it is the big establishments not governed by the Minimum Wages Act. In fact, liable to pay only less bonus, but small establishments covered by the Minimum Wages Act made to pay higher bonus that injustice or that's a clear case of discrimination according to me. So this discrimination is what we challenged before the high courts. And the high courts prima facie, as I said, normally they don't entertain the writ petitions against the amendments. But considering the merits of the matter, prima facie, all the high courts felt that there is some injustice. And all the high courts passed interim order also, staying the operation of the retrospective effect of the amendment. And some high courts, again, the minimum wages payment of bonus on minimum wages. So when the different orders passed by different high courts, and also this being an amendment to the central statute, and further, it's a nationwide issue. We can have impact if different judgments are passed by different high courts. The Supreme Court felt that it is not proper on the part of the Supreme Court to be silent on this issue, because the high courts, if permitted to pass judgments on their own, there is a possibility for the high courts to pass different judgments. So some high courts will allow the writ petitions, some high courts will dismiss the writ petitions, and some establishments in some states will be benefited if the writ petitions are allowed, and maybe other establishments in other states, if the writ petitions are dismissed, then again they have to follow the retrospective effect. They have to pay the bonus, and they have to, again, computation will be on minimum wages. So considering that there is a possibility for different verdicts to be delivered by different high courts, the Supreme Court finally decided to pull all the files to the Supreme Court. And hence, they directed the high courts to send all the files challenging the payment of amendment to the Payment of Bonus Act to the Supreme Court. And the Union of India also cooperated with the Supreme Court. They also wanted the Supreme Court to hear the matter. So they also, the Union of India also filed a petition to transfer all the cases pending before various high courts to the Supreme Court. So all files went to the Supreme Court. That was actually a very brilliant idea. And the Supreme Court should have heard the matter, and the Supreme Court could have taken a decision in the matter. But unfortunately, after almost 5 years, that is in 2021, the Supreme Court, after hearing the Union of India, the Attorney General, and also the representatives of some of the establishments, finally decided that this being a challenge, though it is a challenge against the amendment brought in by the legislature, ultimately the writ petition is filed before the high courts, and the high courts have to consider the issues involved first. And at the first stage itself, the Supreme Court need not consider, or rather hear the matter at length. And it's not proper on the part of the Supreme Court to take a decision which otherwise should be the last decision according to Supreme Court. So the first decision has to come from the High Court. The view expressed by the Supreme Court, and Supreme Court sent all the matters back to the High Courts. So unfortunately for the establishments, all these files which were called for by the Supreme Court were all sent back to the High Courts, and hence the High Courts had to take decisions in the matters. Then the High Court, of course, initially maybe 2022, there was no nothing much happened, and it was 2021, all the files were returned to the high courts. But in 2023, September, this matter was heard by the Division Bench of Patna High Court. And the Division Bench of Patna High Court heard this matter and by the Chief Justice and also Justice Partha Sarathi. Chief Justice is Justice Vinod Chandran, who was elevated from Kerala High Court. And coincidentally, Justice Vinod Chandran is the judge who passed the interim order in these matters, because I argued before him, and he passed the interim order staying the operation of the amendment to the Payment of Bonus Act. But unfortunately, when this was heard, finally, because he was subsequently promoted and transferred as Chief Justice of Patna, and sitting in the Supreme Court, sitting in the Patna High Court as Chief Justice, he heard the matter, and his companion judge, Justice Partha Sarathi, passed the judgment, which of course is a division bench judgment, because Justice Vinod Chandran also accepted that. So that judgment, unfortunately, considered only 3 points, or rather the council there appearing for the establishments raised the 3 points, because according to the council who was appearing for the establishments, first the retrospective effect given to the amendment, that according to the council, normally the amendments are brought in only with the prospective effect, not with the retrospective effect. That is partly correct. What he said is correct, and that is to be the submission on that aspect is correct. But the Supreme Court had a different view on that. The Patna High Court Division Bench had a different view on that. The Division Bench felt that any amendment brought in by the legislature, as I explained to you, according to them, there was a judgment of the Honorable Supreme Court in the case of JM and Company. That was also an amendment challenged in 2007, was made with retrospective effect, and that was challenged. And that judgment, the Honorable Supreme Court has said that the issue on retrospectivity, when it comes to physical legislation, the legislature has power to make the provision retrospectively. Nobody has a dispute. Legislature has powers to bring in any amendment with retrospective effect. So the Supreme Court also said a law cannot be held to be unreasonable merely because it operates retrospectively. Correct. You can't say it is highly unreasonable. Then the unreasonability must lie in some additional factors. So there has to be additional factors to it to explain or establish that it is unreasonable. So the question is, the retrospective operation of a fiscal statute would have to be found to be unduly oppressive and confiscatory before it can be held to be unreasonable as to violate constitutional norms. There is no violation of any constitutional norm. Where taxing statute is plainly discriminatory or provides no procedural machinery for assessment and levy of tax, or that is confiscatory, courts will be justified in striking down the impugned statute as unconstitutional. Only in such situations. So, first of all, it has to be established before the court that it is highly unreasonable. And according to the division bench, this cannot be said to be unreasonable because they made it with retrospective effect from 2014 April. Thereby, it's just one more accounting year, because the amendment was brought in January 2016, but with effect from April 2014. So only 14-15 accounting year is to be reconsidered, or rather revised or reworked. But otherwise, it cannot be said to be unreasonable. This is the finding of the division bench of the Patna High Court. And the question whether it is illegal, legislature can bring in amendment with retrospective effect. So it is not illegal. Whether it is unreasonable, the division bench felt that it is not in a very, it is not affecting the establishments in a very, that is, it will not have that kind of impact what you are explaining, like, or rather, you can't say it is highly unreasonable. So the Supreme Court, the division bench of Patna High Court finally passed the judgment holding that this amendment is reasonable. And regarding the minimum wages also, the Patna division bench was not inclined to interfere with the amendment. So Obviously, maybe it is the difference is, if you look at it, Patna High Court or even Madras High Court, both the High Courts division bench passed judgments dismissing the writ petitions. And the Kerala High Court could only follow that because Kerala High Court, it was heard by the single judge. Justice Iswaran heard these matters. So Justice Iswaran, in fact, is totally helpless because he is compelled to follow the division bench judgments passed by other high courts. Because it's naturally they have to follow that, especially when it is delivered by Justice Vinod Chandran, who was elevated from Kerala High Court as Chief Justice of Patna High Court. So Justice Vinod Chandran or Justice Iswaran explained in court that, see, this is it. If at all you have a case, if at all I want to consider and accept your submission, I can't, because there are two division bench judgments delivered by Madras High Court and Patna High Court. These two judgments stand against you. This is actually what happened in Kerala High Court. And of course, in fact, we were not even heard. If you look at the judgment, it is clear that he just followed the judgments delivered by the Patna High Court and the Madras High Court, and then of course held that the writ petition is only to be dismissed, and he dismissed it. So this actually what happened. And if you look at the manner in which the judgment has been passed, it is, of course, the High Court, the Supreme Court, the High Court division bench, if you ask me whether they have considered. But the impact of these judgments, whether the Patna High Court has considered, I don't think the division bench has considered the impact of these two judgments in a manner, maybe for a reason, because I do not know much about the minimum wages in Bihar. But Kerala, there is huge difference between 7,000 and the minimum wages. Bihar, there may not be much of difference. So the establishments felt that, okay, fine, there is no much of difference. So whether it is 7,000 or minimum wages, for them, maybe it's more or less same. So they probably would have left it like that, or rather the High Court also would have thought it that. But unfortunately, the High Courts, when two High Courts pass that to division bench of two High Court passed judgments, no other High Court normally will pass a judgment against that, or they will never express a different view, because you are challenging one statute, one amendment. So the same amendment is challenged before various High Courts. So the High Courts cannot speak in different voices. One High Court allow the writ petition, another High Court dismissing the writ petition, then third High Court again allowing. So this should not happen. So what happens is, when these kind of judgments are delivered, normally it is circulated, or rather it is being informed that the High Courts have passed on judgments. So Justice Iswaran was very much aware about the judgments passed by the Patna High Court and also the Madras High Court. In fact, I was also aware of these judgments, but tried to, even the council, all council appeared for the establishments here in Kerala High Court, tried to distinguish, or rather explain. But the problem is the single judge hearing the matter, being an inferior court, could not have accepted any of the arguments or passed a different judgment. Of course, that will probably could even be interpreted as judicial indiscipline. So no single judge would be ventured to do that. So here the single judge just followed the division bench judgments delivered by the Patna High Court and also the Madras High Court. So now the question is whether these judgments are the judgments delivered by the division bench are legally correct. So it is actually retrospective effect they have explained. It is not unreasonable. Maybe you can say it is legally correct. There is no illegality in that. But you look at the practical side of it. All corporates closed their accounts maybe with effect from 31st March 2015. And then suddenly an amendment is brought in with retrospective effect from 1st April 2014. So obviously, that will have an impact, a serious impact to most of the corporates, because they definitely will have to. Now, suppose since the stay was in force, probably nobody thought about it or nobody had an issue regarding that. But now, since the writ petitions have been dismissed, the corporates definitely will have a problem because they'll have to rework or rather reopen the entire accounts from April 2014 onwards, and then redo the bonus, allocable surplus, available surplus. All these have to be done with effect from 1/4/2014 on one side. And the second, it is again on minimum wages. So that is again an additional financial burden. And second, it is, the additional financial burden with effect from 2014. And for the past maybe 10 years, it has to be reopened. And so the financial implication, if you look at it, most of the establishments, it's huge. It is, you cannot imagine. Some establishments having, because some of the establishments contacted me. They are having maybe 5,000 employees or 7,000 employees. So in their case, look at the amount involved. You cannot imagine the liability, the financial liability, and the minimum wages. Now it is the way it has gone up during the period from even from 2014 to 2024. If it is reopened, maybe in the plantation, because Mr. Gilbert is here and Mr. Jyotish is here, both are from plantation sector. So they are aware of the wages, what was prevailing in the plantation sector in the year 2014. And after 10 years, that definitely would have gone up by 100%. So when you rework the bonus, and all of them are again under the Payment of Bonus Act, governed under the provisions of the Payment of Bonus Act, because they are salary of all the employees, the workman category working in the plantations, it is still below 21,000. So they are all governed under the provisions of the Payment of Bonus Act. So in their case, right from 2014, last 10 years, they have to reopen. And the financial implication on one side, second, the auditors, all the audited books have to be reopened. And some companies probably would have kept provision. Probably most of them would have done it because nobody knows what will happen to these cases. Though, because I actually never expected this kind of judgment, because I thought the court at least would consider the minimum wages and also the retrospective effect, the two questions raised before the court. And the Patna High Court passed the first judgment, and Madras High Court followed that. Then Kerala High Court also was compelled to follow that. So actually, these matters, if you look at it, the establishments which kept the provision for Payment of Bonus Act, maybe last 10 years, if you have the provision, if you have the money with you, or rather if you have kept the provision, then obviously things will be easier for you. So you need only disperse it, and you can probably save but the establishments which have not kept a provision for the payment of bonus in case the writ petitions are dismissed, probably they will have a tougher time because they won't get any exception, and the liability then will be huge. And for the period each year, they have to work out the bonus, the percentage of bonus based on the allocable surplus, and then work it out, and what will be payable percentage, there won't be any difference, but the amount, there will be huge difference. So that is actually the impact of this. So now the solution, since the high courts across have passed or passing judgments dismissing the writ petitions. Maybe some judges, some courts, it is already decided by the division bench, and in Kerala, it is decided only by the single judge. So if it is decided by the single judge, then you have to file the writ appeal before the division bench. And if it is decided by the division bench, you have to file it before the Supreme Court. So since some high courts have already, the division bench have already decided this, even if a writ appeal is filed before the division bench in Kerala High Court or any other High Court, the division bench also may not entertain that because other High Courts, other division bench have already decided. And hence this division bench here also will be compelled to follow that same judgment. Ultimately, a decision can be taken only by the Supreme Court in these matters. So, considering the financial implication and also the impact that can have on the establishment can take a decision whether to file a writ appeal and then go to Supreme Court, because the division bench also probably the establishments cannot get a relief from the division bench of any High Court, including Kerala High Court. Even if you file the writ appeal in, but that you cannot avoid either, because you cannot go straight to Supreme Court. You can only go through the division bench. Since the judgment has been passed by the single judge, you have to necessarily file an appeal, writ appeal before the division bench, and then that is dismissed, you go to Supreme Court. You cannot straight away go to the Supreme Court. So, but anyway, division bench judgment will be only a formality, what I feel, because there are several judgments passed by different High Courts, division bench itself. So here also the division bench will only follow the same judgment. Then finally, the matter will have to be decided by the Supreme Court. And the establishments, depending on the financial implication, can take a decision whether to file the writ appeal and then go to Supreme Court. So, considering the legal issue involved, and also the Kerala probably will be the worst affected, because the minimum wages rates are probably in Kerala it must be the highest. So obviously, if you compute the bonus on the minimum wages in Kerala, the financial liability will be huge, unlike other states. Maybe Tamil Nadu, the minimum wages variation, maybe it is 10,000, and otherwise you have to work out or compute on 7,000. And if minimum wages is 8,000 or 9,000, the liability will be less. But in Kerala, even in the shops, it is 14,000 as on today. And maybe from 2016, 17 onwards, it is around 12,000 to 13,000, 14,000. And the hospitals will be again be affected, because it is 21,000. Some hospitals are paying about 21,000 now. So their case, of course, about 21,000, the management is not liable to pay bonus. And the hospitals not running on profit also are exempted from the purview of Payment of Bonus Act. So it's not going to affect them either. But other establishments, other corporates, other establishments definitely will have to take a decision to challenge it, firstly before the division bench and then to the Supreme Court. So this is regarding the solution. So there you can take a decision, and according to me, the Supreme Court has to interfere with this judgment, because it is actually, this is not the way it should be considered, or rather, according to me, because as I said, the Bihar, probably the impact would be less. It is 7,000 and the minimum wage, suppose, is only 8,000. So the impact is less, but in Kerala, the impact is high. That is actually probably that, but legal, when you come to law, the High Courts cannot consider whether the minimum wages is high or the financial implication is high. These kind of things, the High Court cannot consider in these writ petitions, because here you are challenging the constitutional validity of an amendment brought in by the legislature. So whether that amendment is constitutionally valid. So that is why the Patna High Court did not go into the facts. The Patna High Court did not go into the facts at all. The Patna High Court did not consider what will be the impact or the minimum wages, how much it will be, and for an establishment, maybe with the 2,000 employees, which for the minimum wages is not applicable, then the bonus will be less. But an establishment having 50 employees covered by the minimum wages, the bonus will be much more. These kind of things the Patna High Court has not gone into, especially because you are challenging only the constitutional validity of the amendment. So the factual aspects generally are immaterial. But in Kerala High Court, considering the financial implication, probably Kerala High Court probably would have considered that if you explain, because there is an element of discrimination also. Because as I explained, if, for example, IT sector was not governed by the Minimum Wages Act till recently. It is, I think it is brought under the Minimum Wages Act very recently. So before that, it was not governed by the Minimum Wages Act. So then it is some companies having maybe 10,000 employees or 8,000 employees. So they were, again, the computation of bonus will be only on 7,000. Maybe that is their employees are drawing more than 21,000. So the act itself is not applicable. But otherwise, what I'm saying is some rich companies, rich corporates, even they are contract workers, the bonus will be only 7,000 if the minimum wages is not notified for that industry. But a hospital, as I explained, is a small hospital with 50 employees. Bonus Act is applicable, and the minimum wages, if considered for the purpose of computation of bonus, it will be very, very high. The liability will be huge. So this distinction, or rather the discrimination, the amendment, how it discriminated among the industries covered by the Minimum Wages Act, not covered by the minimum wage. This actually Article 14, whether it is of the Constitution of India. That way, if you look at it, whether it is unconstitutional or not, because there is violation of Article 14. Unlike other, it is minimum wages need not be or cannot be linked to bonus. Suppose the two for the purpose of gratuity. Again, suppose such an amendment is brought in. So it is on minimum wages, or so it is actually and without this 20 lakhs ceiling. See, it is minimum wages if you work it out, or rather you forget minimum wages. Two types of gratuity calculation under the same statute. How is it practical? How is it possible? Because there is one statute, and all establishments are governed by the statute, and you have to follow all the provisions under the same statute. So whatever is applicable, whatever is payable under the statute, all establishments have to pay, or rather have to compute in a similar manner. So there can be two ways of calculation of the statutory benefit. So it is like you gratuity, one establishment is 40 lakhs, another establishment is 10 lakhs, third establishment is 20 lakhs. You can't, because it's all governed by one statute called Payment of Gratuity Act. Similarly, there is only one statute called the Payment of Bonus Act. So it is a one statute, and different establishments, you can have different bonus, and you can have different percentage. That is going by the calculation section 10 or 11. You can have different minimum bonus or maximum bonus depending on the allocable surplus. You can. That we understand. But the minimum, that is computation, for the purpose of computation, when you give a ceiling, that ceiling, whether 7,000 or another ceiling, for some establishments, another ceiling, that is not practical, that is not proper. Suppose minimum wages, it is 15,000 for some establishments, and then 50,000 for some other establishment. Is it practical? So that is not practical, or rather, it is, according to me, it is that is not legally, or I shouldn't be saying legally incorrect, because it's already upheld by the division bench of the high courts. So legally, it may not be proper on my part to say that it is. But there is an unreasonable in that. That there is an unreasonableness in the amendment brought in by the government, by the legislature, that way, if you look at it. So these questions probably the Supreme Court may consider, and Supreme Court probably may understand the consequences, and Supreme Court may interfere. But from Kerala High Court, now you cannot go directly to Supreme Court. You can only go through the division bench. Division bench, I don't think will even admit it. Very unlikely, because considering the judgments delivered by other division bench of other high court, the division bench here only will dismiss the writ appeal. Of course, then you can go to Supreme Court. Supreme Court, of course, you can at least you have to give a try. Supreme Court, it is because you know that it is what's happening in Supreme Court. We all know, because it is today they may entertain a writ petition. I mean, SLP. Tomorrow they may not. So that way, in fact, depending on the attitude of the judges, depending on the law laid down by the Supreme Court earlier. So considering all these, probably, but now it is considering the financial implication. According to me, the establishments having high financial implication cannot leave it at the judgment of the single judge level. It has to be taken to the highest level, to the Supreme Court, and let the Supreme Court decide. Because suppose the Supreme Court finally decides or feels that it is highly unreasonable and ready to interfere, then of course we are safe. But if you don't go to the Supreme Court, then Supreme Court, you lose the chance forever, and then you no option to the only option is to comply with this. This actually is the impact of this, and also the solution, as I said. Either comply, if you have kept the provision, probably you can consider complying with the judgments. But if you have not kept the provision, it's worth taking it to Supreme Court, considering the amount involved. And also your industry. Minimum wages, what is the minimum wages payable? So it is 7,000, and that minimum wages, what is the difference? Kerala will be the worst affected. Other states.
Very affected.
One day.
One establishment, plantations. One section of workers are having notified minimum wages. The other section, the staff doesn't have any. So worker will get more bonus than the staff. Plus, you are paid bonus on the 7,000 taking. So now when it goes up on minimum wages, the workable surplus will come down. When you take back what you have paid more, out of paid 20, today it becomes 16. You're reworking it. That's another thing which you already talk about financial implications. I'm talking about the other implications.
Correct. So there can be social implications also. So it is, as Mr. Gilbert said, that is, of course, there can be social implications, because the person drawing higher salary, maybe 20,000. Mr. Gilbert was giving an example. So a staff working in a plantation, his salary may be 20,000 a month, and a worker, his salary will be 10,000 or 11,000 a month. So when you consider, or rather compute the bonus, the workers are governed by the provisions of the Minimum Wages Act, but the staff are not. So the staff drawing 20,000, his computation of bonus will be on 7,000, but the workers' computation of bonus will be on 10,000 or 11,000, because this is notified by the minimum wage. So then again, social impact, a person drawing higher salary will get less bonus. Person drawing low salary will get higher bonus.
So the percentage already declared.
Yeah, percentage is already declared also. So percentage remain the same for all. And all are governed by the same act.
Okay.
All are governed by the same act.
Percentage will come down.
Yeah.
Already.
Yeah, it will come down.
And I can't take it back.
You can't take what is already paid. So that way, if you look at considering the impact, the plantation sector, probably considering the number of employees and also the number of companies, definitely they will go to Supreme
I
Court.
think other people have established in other states. You have minimum wage and you pay to that. Other states we have lower minimum wage.
Yeah.
So you have two plus.
Maybe some states even minimum wages will be less than 7,000. So
two counting of minimum.
yes,
Basically,
that is it.
in a
Yeah, so it
plan.
is the same company, two states where the minimum wages is more, the minimum wage is less. Then two types of bonus you will pay. It's all that is minimum wages definitely should not be linked with the bonus. So that is not even the Supreme Court has said that it is.
Whatever the trust people have, is the minimum wage part should be challenged.
Should be challenged. Should be challenged. This is what I.
Open the door for other statutes getting amended on minimum wage, graduate can get amended on minimum.
Yes. Again, it is that way if you look at it, because the hospitals will be the worst affected.
Worst.
Yeah, because they are minimum wages. Now it will be notified soon. Discussions are on. And now they already started, union started submitting the strike notice and all those things. So that way.
And in Kerala, unlike other states, the minimum wage will change every month because it is dependent on the DA. Whereas in other states, the minimum wage is common for same for one financial year. In Kerala, it changes every month.
DA. You mean DA?
DA changes accordingly. The minimum wage also will change every month.
Correct.
Then the calculation would be too cumbersome, too much difficult.
Yeah. Minimum wages, the computation will be on the total wages you have to consider for arriving at 8.33% or 20%, whatever it is.
Yeah.
What will be the chances in the division bench on minimum wages impact?
So the Kerala High Court division bench cannot entertain this because other high courts division bench has already decided.
They have not considered the minimum wage impact.
Correct. But even if you file appeal here, the concept is the amendment, the repetitions have been dismissed. So one portion, whether the division bench here will consider difficult. And especially
That
the
means the only chance will be going to pursue the Supreme Court.
Supreme Court. See, it is here it is, you look at, because the division bench here is, I don't want to put it public. Because-
We can-
7,000.
Yeah.
Hello, we was asking.
See, in the context of
whether there
the
is any
labor code coming in, is there any
impact.
impact?
No. When the labor code comes, see, today, this 7,000 and 21,000 throughout India it is same. When the labor code comes, it will be entrusted to the state governments to decide what will be the amount for the calculation and what will be the amount for health. So, throughout India, it will not be same once the labor codes come.
When you say based on.
So how it is going to impact Kerala?
No.
No, Varghese sir, how it is going to impact Kerala? Because I think most of our members. join.
Kerala, definitely, the Kerala government will definitely increase compared to other states. The 7,000 will go up. And yes, 21,000 also will, definitely it will go up. Because with respect to all other statutes, we are much ahead of other states as far as these benefits are concerned. So when all other states pay only 8 or 9 days, national and festival holidays, we are paying 30, that too from 1990. It is 34 years. 34 years back, we started giving 13 days.
The other states are on 8 to 10 only. There's not impacted the other states.
When is that the division of the definition of wages still at basic plus DA, right? You can take any
Yes,
other
yes.
stand that
No,
21,000
that-
shall include only basic plus DA.
Only
You
basic
can't
plus
take
DA.
odd wages or something like that. No stand
No,
cannot.
only basic plus DA, but the minimum wages notification, if you pay it on minimum wages notification, if you the judgment delivered by the judgment delivered by the Supreme Court, the minimum wages, if you work it out, that need not be paid as basic plus DA. But that can be paid in different components, and that is accepted by the Supreme Court also. DA is not a compulsory component, is what the Supreme Court has said. So, strictly speaking, basic plus DA, if you work out for the purpose of coverage, persons drawing only less than 21,000, the act is applicable.
Okay.
Thank you, Advocate
Thank you, Bannister.
Benny Thomas. Now it's a time for a few more questions. If you have any questions, you can share it now.
So if the bonus is paid now, sir, we have to pay it for the minimum or 10,000? If a company
the-
want to pay it
No.
bonus today, shall we pay it on 7,000 or minimum?
See, if you decide to file appeal, you pay it on 7,000 and they give a letter to the union stating that you are challenging the judgment. Now they rely on this judgment.
That's right.
So you
So
have
they
to
are,
say
they are
that,
beyond this,
yeah, because it is Upasi's judgment they will rely on.
yeah, that's true.
Yeah, they will say that Upasi challenged it and this is the judgment, so that obviously it is. But naturally, it is, I think, Mr. Gilbert, it is APK also challenged it separate.
Yes.
APK and Upasi, or Upasi only challenged it.
Gateway charge is also.
Upasi also challenged. So that way, if you
It's
look at it,
required to change in the High Court in Kerala. Instead of that, if Tamil Nadu, Upasi take up in Supreme Court, shall we
Supreme Court, Tamil Nadu, of course, they can, I think it is Tamil Nadu Division Bench was the judge.
Yeah, that's what. So if they take it to Supreme Court, along with that, can Tower Plantations also join?
Yes, yes.
Instead of filing a.
Any establishment taking it to Supreme Court, and if you get an interim order, then it is as good as interim order staying the operation of the amendment itself.
And that can be applicable to all states.
Yeah, yeah. That will be applicable to all establishments, can take advantage of that, saying that it has been stayed by the Supreme Court.
So as of now, no one has approached Supreme Court because Madras High Court has given the verdict about 2-3 months back, right? So
Yes,
no one
Madras
has
High
approached
Court.
Supreme Court now.
Yes, even the Madras High Court, of course, the Supreme Court, to approach the Supreme Court, you have 90 days time. But Patna High Court, normally they should challenge it. Because the only reason why I feel that they wouldn't have gone to Supreme Court is the minimum wages in Bihar will be less. So the financial implication will be less. That could be one of the reasons, because I have to check because I'm not very clear whether the Patna judgment has been challenged before the Supreme Court. That I'm not very clear, because I have already asked my contact lawyer in Supreme Court to find out, and probably that is I'll be traveling to Delhi during the last week of this month. You can find it out, but that, of course, based on that only you can take a decision. But whether there is an interim order or not, we do not know. But Opasi, probably the plantation companies may go to Supreme Court based on, challenging the judgment passed by the Madras High Court.
There is one question, please. You can ask the question, please. Somebody's raised a hand.
Hello, very
Yeah.
good evening. Actually, Mr. Advocate Benny P. Thomas has already explained the nitty-gritty of the payment of bonus act very well. I appreciate that part, but this point has been taken only from the employer point of view. Normally, an employee, especially the minimum wages, is guaranteed of maximum is 21,000 or something like that. It is very low amount for a family to maintain his family.
Sir, minimum wages is not a challenge at all. I support the minimum wages, and according to me, all establishments have to pay minimum wages. We are only on the bonus. Whether the bonus calculation, see, for example, I tell you, a rich corporate not governed by the minimum wages need pay bonus only on 7,000. But a poor employer, unfortunately governed by the Minimum Wages Act, has to calculate the bonus on minimum wages, maybe 15,000 or so ultimately the poor employer will pay higher bonus and the rich employer will pay very lower bonus. That discrimination is what I was pointing it out. I am not on the minimum wages. Minimum wages, definitely, whatever it is, all establishments have to pay. Whatever is notified, the establishments have to pay.
But
No doubt about that.
actually, all these aspects has been considered by the central government before passing the modifying the Payment of Wages Act. Actually, retrospective effect, it is not a problem at all. Because in many of the organizations, whenever there is a wage revision, it happens with retrospective effect only. One part. Second part, whenever there is a provision, it is not that they have to open the complete every month, every year's profit and loss account. They make the provision for that payment of bonus.
It is your, sir, it is regarding the payment of salary, all settlements are signed, generally all settlements are signed with retrospective effect. No issue, because every employer knows that suppose your settlement expired in 2021 and you are signing a settlement in 2023, the employer is fully aware that he is liable to pay the arrears of salary maybe from 2021. So they keep a provision for that. But the Bonus Act, the amendment is brought in by the legislature, and the legislature suddenly bring in an amendment which the employers are totally unaware of. And then that is made with retrospective effect. And naturally that will have an impact in all the corporates. That is what in fact I was pointing out.
But we have to see from the perspective of a poor employee also. The maximum amount payable will be around 10,000 or so, not more than that one.
Which one?
And
bonus?
Extra bonus, whatever will be there.
No, bonus will be definitely not 10,000. 10,000 will go on.
Then what are the difference? So I am talking about the difference of bonus will be around 10,000 to 12,000 something maximum, not more than that. Yeah,
No, see, that is a
14,000,
minimum-
14,000 maybe.
No, that is, suppose it is a hospital where they are paying 20,000 salary is paid to the nurses. So
Mhm.
that 20,000, if you work out the bonus, it will be around 50,000, where otherwise they would have paid us 12,000 or 13,000. So the difference is around 25,000 in respect of one employee.
So 8.33% you are talking about? That is 8.3.
I'm not on 8.33, I'm on 20%. 8.33 will be only 7,000 and 7,000. Now instead of 7,000, it is 20,000. So instead of 16,800, it will be around 50,000.
Anyway, once the government has considered all these aspects and taken a decision, we should respect it and move forward.
I fully appreciate that. And I don't know which establishment you are representing. I don't know whether you are representing an establishment or you are an employee. I do not know. So it is definitely you can, if you are representing an establishment, you can decide not to challenge it. And definitely I appreciate your benevolence. And because it is, I am not personally, I am not affected in any manner because I am not running an establishment and I am not governed under minimum wage act. I am not governed by the Payment of Bonus Act. I have a very small office so that it is, I am not personally affected in any manner. The legal side only I explain. The moral side, of course, I fully appreciate. I am with you. Moral side, I am with you. Whatever the employer can pay, employer has to pay to the poor employees. I appreciate that. Considering the high cost of living in Kerala, whatever the employer can afford or can pay, they have to pay. Okay.
Yeah. We can take one more question if it is there. Any clarification, please? Please. If there is no other question, probably we'll wind up. Before that, as a token of our love and affection, we would like to present a small memento to Advocate Benny Thomas. Thank you so much, sir. It's very informative, thought-provoking. Thank you so much. Now, may I invite our program committee chair, Mr. Anil Kumar, to propose the vote of thanks.
Thank you, Johnson. Good evening, everyone. A very good discussion because, especially law is especially a subject which is difficult to be digested. At the same time, labor laws are much more, boring sometimes or even, difficult to debate and all. But at the same time, this is something that has created a lot of disturbance among the employers as well as employees. And this amendment, I think after 9 years, we are discussing this amendment. So that means it has got its own, strong relevance that continues in the industry. And some of the things that I also observed is that some states, whether the staying was not happened, the employees have already received the increased bonus. And some states, the stay happened from the court. There is challenges. As Advocate Benny already mentioned, that the administrative challenge involved with employers over the years, when it comes to, it's actually a very huge challenge. It's not very easy to rework on all the financials of the last 8-9 years. It's not a very easy task, and only the people, those who are involved in it, especially chartered accountants or the financial department, understands that how much it will be difficult for somebody to calculate it back. And then again, you have to rework on everything. And some of the public limited companies may have to even answer to the shareholders also as an impact of this. The financial impact has to be answered to the shareholders also. So a lot of challenges are there when it comes to, and it can also even, it sounds like that even an amendment like this is going to create labor unrest or even IR issues and all in the coming days, because on the one side the employer has got the challenges, and the other side the employees definitely will be asking for the enhanced benefits and all. So definitely a subject that is of very, very large impact. And unfortunately, when it comes to Supreme Court, I think Supreme Court will not be thinking more about Kerala. Supreme Court also will be thinking about the whole of the country, and what happens in Kerala or what is relevant for Kerala or what what is the kind of challenges that the Kerala environment faces will not be the priority sometimes, and it can be quite challenging for many of the companies in this part of the country as well. And many companies have got, for example, companies have got units or or establishment in multiple states will have multiple challenges. Somebody has got Karnataka, somebody has got Ahmedabad, or even some other places. There again, the stay order or the interim orders actually impact in multiple ways, and employer will get actually confused. And where there is a federation of union, then you will have bigger challenge, because how do they actually represent all the employees across the organization when they have a federation and all? So multiple challenges are they are connected with this, and I think it should have been thought out very well before an amendment has brought in. But at the same time, once the law is made, we are expected to abide by the law, and the law of the land is supposed to be adhered to as well as respected. So having said that, but within the limited time, Advocate Benny has explained and enlightened us with all the possible inputs, and also the participants interacted and engaged with him very well. So I take this opportunity. First of all, I thank Vinod for initiating this discussion. Vinod is a person who has actually started this discussion, and immediately we discussed, and within a short period of time, thank you for initiating the discussion. First, thanks to you. And Advocate Benny, thank you very much for preparing yourself. You don't require any preparation. I don't think that you require a preparation, because you have been continuously working on it. And thank you very much for being here and also enlightening us with your knowledge. And thanks to Johnson, Shema, and the entire executive committee for allowing us to organize such programs, and all the participants, very active participants, all of you who have engaged very positively and actively, and your doubts are the value addition for these kind of programs. The more curiosity, the more doubts comes up, maybe the more awareness is created. And let's continue to have such kind of discussions. And thank you very much, all the participants. Thanks to all of you. And I take this opportunity to wish you all and your family members a very happy, prosperous, and safe Onam. And looking forward to meeting you again with some good programs. The L&D committee is committed to having some value-adding programs in the months to come. So thank you very much, and good night, everyone. Thank you, Johnson.
Yeah, we can wind up the session. Thank you, everyone.